Namaskar and good evening to all. On behalf of Akhil Adhivakta Parishad Devgiri Prant, I extend a warm welcome to everyone present for today's lecture in this important guidance series for District Judge and JMFC Civil Judge Junior Division examinations. It is my proud privilege to introduce today's esteemed speaker, Professor Dr. Dinesh B. KOLTE. Sir has an outstanding academic and professional journey. He completed his LLB from MP Law College in the year 2000, securing first rank in the university and was awarded a gold medal for his excellence. He further pursued LLM in criminal law and torts from Dr. Babasaheb Ambedkar Marathwada University, again securing first rank in order of merit. Adding to his academic achievement, he also completed LLM in a constitutional and administrative law from Usmania University. Sir has also demonstrated exceptional merit by qualifying the UGC NET examination 3 times and SET examination once. In his professional career, he served as JMFC and Civil Judge Junior Division from 2004 to 2006. Thereafter, he dedicated himself to legal education and has worked as lecturer in law at New Law College, Ahilyanagar, SS Maniyar Law College, Jalgaon, and Dr. Ambedkar College of Law, Chhatrapati Sambhajinagar. Presently, he is serving as a professor of law at MP Law College, Chhatrapati Sambhajinagar, and is also a PhD guide, contributing significantly to legal research and academic development. Today, he will guide us on the highly important topic of Juvenile Justice Act 2015, which is crucial both for examination perspective and for deeper understanding of child rights and justice. We are truly fortunate to have such a distinguished personality among us today. Without taking much time, I respectfully invite Professor Dr. Dinesh B. KOLTE sir to deliver his valuable lecture. Thank you. Sir.
Thank you, sir. सर जॉइन होता है क्या कई लोग यूट्यूब लाइव का गुड इवनिंग टू ऑल रिस्पेक्टेड प्रवीण पाटिल सर, Advocate Prant Patil sir, respected Advocate Dr. Sangeeta Bagul, Madam. Today, I am going to deliver the lectures on the important topic, that is the Juvenile Justice, Care and Protections of Children Act 2015. See friends, why the legislature repealed the earlier 2000 Juvenile Justice Act and they enacted the new act. They enacted the Juvenile Justice Act 2015. What are the reasons or what is the main reasons behind the enacting of this act? See what happened on 16th December 2012. One incident happens in Delhi, that is Nirbhaya rape case. In that case, 5 accused persons committed the rape on the Nirbhaya, and one of the accused was a 17 years old, who was short of 18 years of age, and who had committed a lot of atrocities on a Nirbhaya. He was arrested, he was apprehended under that law. He was awarded 3 years imprisonment in observation home, and after 3 years period, he was released from the jail for the sake of understanding. Then what happened? People started agitations that a law should be changed. A law should be changes. And we should enhance the punishment for those children who have attained the age of 16 years who have completed 16 years of age or above 16 years of age, under 18 years of age, that they should be tried as like an adult offender. And therefore, in view of these suggestions made by the various committees, and in view of this, the Parliament enacted the Juvenile Justice Care and Protection of Children Act 2015. And this act made that the child who has completed 16 years of age and or above 16 years of age and under 18 years of age, and if he has committed heinous crime, and if he has attained mental and physical capacity, and if he understands the consequence of it, then that child should not be tried as a child, but that child should be tried as a adult offender. This provision was made here. Therefore, see the provisions. What is a doctrine of duly incapacitated? Sections 82, 83 of IPC and sections 20 and 21 of the Bharatiya Nyaya Sanhita. What this section says. See I prepare the chart, the concept of infancy. Section 82 of the IPC and sections 20 of the Bharatiya Nyaya Sanhita says, nothing is an offense which is done by a child who is under the age of 7 years, and that he has an absolute immunity. That was the provisions under sections 82 and under section 20 of the BNSS. Again, section 83 of the IPC and 21 of the BNS says, nothing is an offense which is done by a child who is above the age of 7 years and under the age of 12 years. And if he has, now there are two rules. If he has attained the maturity, then he is liable. It means he can be prosecuted. But if child who is above the age of 7 years and under the age of 12 years, and if he has not attained the sufficient maturity, what is right, what is wrong, then that is not an offense as per sections 83 of IPC and sections 21 of the Bharatiya Nyaya Sanhita. Then third category is the child who is above the age of above 12 years of age. He is liable. It means he is prosecutable. This is the chart, and this we also these sections 80 to 83. Here some provisions have been made for the protections of the children in an Indian Constitution. See, clause 3 of Article 15 says, in view of the provisions of clause 3 of Article 15, the Parliament enacted and created a separate category of the children. Here, clause 3 of the Article 15 says, nothing this article shall prevent the state from making any special provision for women and children. It means clause 3 of Article 15 empowers the central government, state government, parliament, state legislature make a special provisions for it. In view of this, they enact the special act, that is Juvenile Justice Protection and Care, Juvenile Justice Care and Protection Act. Then there are various regions about Article 39, Article 21A, Article 45, Article 47, Article 51A. See, under the Juvenile Justice Care and Protection Act, there are 4 types of children in a JJ Act. One is a child in conflict with law. Second is a child in need of care and protections. Third is a child legally free for adoption. And fourth is the offenses against the child. These are the 4 categories of children have been stated in a JJ Act. First, child in conflict with law means who is accused. Child in need of care and protection who is not the accused. Who is not the accused, but who is in need of care and protection. You are a child legally free for adoption. Then offenses against the child. Now here, offenses committed by child or offenses committed against the child. offenses committed by child or offenses see, two things are there. Offenses committed by child, in that time child is an accused, and offenses committed against the child. See here, I prepared the chart. Offenses committed by child means child is an offender and he'll be dealt with under the Juvenile Justice Act. Then offenses committed against child, that time child is a victim. There are two types of offenses committed against child. One is a sexual offenses. Sexual offenses. Then the accused will be liable under the POCSO Act, and then other offenses. Then next, competent authority in a Juvenile Justice Act. What is the see? There are two categories of generally there are two categories of children in a JJ Act for the purpose of our syllabus. One is the child in conflict with law. In order to deal with the child in conflict with law, there are two criminal courts. One is the Juvenile Justice Board, second is the Children's Court. And second categories of the child is there, child in need of care and protection, who is not accused. And for the welfare of the child in need of care and protection, there is a Child Welfare Committee. Child Welfare Committee passed the order. Then here, reports in Juvenile Justice Act. See, reports in Juvenile Justice Act. Here, there are three reports. One is a social background report, which is submitted by the Child Welfare Police Officer immediately after the commission of the offense. And it is produced at the time of the protection of the child before the board. Then special investigation report. This is prepared by the probation officer within 2 weeks from the first protection of the child before a board. Then there is a final report. Whether PPT is visible? PPT is visible? Now, whether PPT is visible? Now see, what I taught. The four types of children are there in a Juvenile Justice Act. One is I will revise it. Child in conflict with law. Second, child in need of care and protection. Third, child legally free for adoption. Then offenses against the child. Then what I said again. Offenses committed by the child. That time child is an offender and he will be dealt under the Juvenile Justice Act. Then child offenses committed against the child. That time child is a victim under the POCSO Act. If the sexual offenses, other offenses, then under the to this book under the IPC or BHARTIYA. Then again, what I told, there are which are the competent authority in a Juvenile Justice Act. For a child in conflict with law, there are two authorities. One is the Juvenile Justice Board and second is the Children's Court. Then another authority is there. Another competent authority is there. The Child Welfare Committee, in order to decide the cases of a child in need of care and protection. The next is the reports in Juvenile Justice Act. See, there are three reports. Three reports are submitted before the Juvenile Justice Board. What is the social background report? It is submitted by the Child Welfare Police Officer immediately after the apprehension of the child. Then second is special investigation report, SIR. That is the probation officer prepared. And it is filed within 2 weeks from the first protection of the child before the board. And there is a final report that is completed the investigation officer within 1 month from the first protection of the child before the board. See how many sections are there, how many chapters are there? See, chapter 1 is there, short title and extent. Chapter 2 is there, general principles of care and protections of children. Then chapter 3, juvenile justice board is there. Chapter 4, procedure in relation to children in conflict with law. Procedure in relation to children in conflict with law. Here, chapter 3 deals with the composition of a juvenile justice board, and chapter 4 deals with the procedure in relation to children in conflict with law. Then next, the child welfare committee. Next, what do you mean by child welfare committee? Composition of child welfare committee and functions of the child welfare committee lies under the chapter 6. That is procedure in relation to children in need of care and protections. Then chapter 7, rehabilitations and social reintegration. Then adoption, other offences against children, miscellaneous. Then offences in a Juvenile Justice Act 2015. Okay, what are the offences under the Juvenile Justice Act? There are 3 offences under the Juvenile Justice Act committed by the child in conflict with law. Okay, here, this act, the child who commits the offense, neither is called a delinquent, nor he is called as a juvenile. And they coin the new term, that is child in conflict with law. That is child in conflict with law. Then child in conflict with law committed 3 types of offences under the JJ Act, or JJ Act provides the 3 types of offences. One is a petty offence, second is a serious offence, third is a heinous offence. Subsection 40 of sections 2 define the petty offence. Petty offence means where the maximum punishment for the offence under the IPC or under any other special law, that is up to 3 years. And this case will be tried by this offence will be tried by the Juvenile Justice Board, and the Juvenile Justice Board has a power to award only 3 years imprisonment, and the Juvenile Justice Board will follow the summary procedure. Here, whenever the Juvenile Justice Board will try the petty offence, okay, petty offence means the offence where the punishment is up to 3 years imprisonment, maximum imprisonment 3 साल. This offence में 3 साल तक punishment is the offence where the punishment is up to 3 years under the IPC or under VNSS or under any other special law. That offence is called the petty offence, and that offence, the petty offence, shall be tried, shall be inquired into by the Juvenile Justice Board, and Juvenile Justice Board will follow the summary proceedings, and a Juvenile Justice Board can award only 3 years imprisonment. Second is a serious offence. This subsection 54 of sections 2 define the serious offence and punishment above 3 years and up to under 7 years. The offence where the punishment is above 7 years of age and under 7 years of age, under the IPC, under the BNSS or under the special law, that offence is a serious offence, and trial means inquiry. Here, take the example in a Bhartiya Nagrik Suraksha Seta. It means in old CRPC, there are 3 stages of a criminal case. One is the investigation, second is the inquiry, and third is the trial. In a CRPC or BNSS, the trial stays from where the court starts to record the evidence. But here, in a Juvenile Justice Act, the legislature has not used the word trial. Here, in this act, inquiry means trial in a JJ Act. Wherever the word inquiry appears in a JJ Act, that inquiry means trial. Try to understand it. Okay, therefore, the child who commits the serious offence means the offence where the punishment is above 3, under 7, under 7 in the VNS or IPC, then that offence is tried as a serious offence. That will be inquired into, is tried by the Juvenile Justice Board, and Juvenile Justice Board will follow the summons case procedure. Which case procedure? Summons case procedure. Then third category offense is here. Subsection 33 of sections 2 define the heinous offense. The first in point of time, the legislature introduced the heinous offense in JJ Act that was not there in an old act. Okay, because of this Nirvas case, they inserted this definition of heinous offense. Then what is the heinous offense? Where the minimum punishment in that offense is 7 years or above 7 years here. Where the minimum punishment in that offense is 7 years or more than 7 years under the IPC or BNS or any other special law, then that offense is called as a heinous offense. Okay. Now there are two types of heinous offense. And again, this heinous offense will be tried either by the Juvenile Justice Board or a Children's Court that will study in a detail in the next slides. The heinous offense committed by the child in conflict with law. Again, this has been divided in two parts. The heinous offense which is committed by a child in conflict with law who is under 16 years of age. The child who is under the 16 years of age, under the 16 years of age, and if he commits the heinous offense, then he will be tried by the Juvenile Justice Board. He will be tried by the Juvenile Justice Board, and Juvenile Justice Board will follow the summons case procedure, and Juvenile Justice Board can award imprisonment up to 3 years. Then here, the child who is above 16 years of age and under 18 years of age, the child who is above 16 years of age and under 18 years of age, the child is above 16 years of age and under 18 years of age. Here the legislature has created the two categories. The child is above the 16 years of age and under 12 years of age. Again, there are two things. Again, they have created two groups. One, the child, though he is above 16 years of age, under 18 years of age, but if the child has not attained the mental and physical capacity, the child does not have the ability to understand the nature, consequences of his act. The child does not understand the consequences, circumstances in which he commits the offense. Then in that situation, that child, though the child is above the 16 or 18 years of age, if second he has committed heinous offense, but if he doesn't attain if he has not attained the mental and physical capacity, then he will not be tried by the Children's Court, but he will be tried by the Juvenile Justice Board, and Juvenile Justice Board will follow the summons case procedure, and Juvenile Justice Board can award imprisonment up to 3 years. Second category, the child who is above the age of 16 years of age, above 16 under 18 years of age. He has committed the heinous offense, and he has attained the mental and physical capacity. If he has the ability to understand the consequence of the offense, understand the consequence of his act, then if he understand the circumstance, in which he commits the offense, then in that situation, then that child will be tried by the Children's Court as like an adult, not as like a child. Okay, and then Children's Court will follow the session court procedure. This I thought to hear about here. I already thought to kinds of challenge Juvenile Justice Act. One is the child in conflict with law, child in need of care and protection. We already discussed it. There is a repetition of these slides. Then in order to decide the cases of a child in conflict with law, there are two, this act has created two forums. One is the Juvenile Justice Board, second is the Children's Court. Okay, child in need of care and protection, child welfare commission. Okay. Now here, what is a child? Child means a person who has not completed 18 years of age. Child means who has not completed 18 years of age. जिसने 18 साल तक complete नहीं की. Child means a person who has not completed 18 years of age. Second, juvenile means a child below the age of 18 years. What is the difference in a child and juvenile? Child means a person who has not completed 18 years of age. Here juvenile means a child below the age of 18 years. Negative sentence, positive sentence. Okay? तो हमें क्या है कि जिसका those who are not attained this 18 years of age, they are a child or they are a juvenile. चलो next. Children in Juvenile Justice Act. We already see this. Child in conflict with law means, see in old act use the word juvenile, but new act did not use the word juvenile. It used the word, it find the new term to the child who commits the offense, that a child in conflict with law means a child who is alleged. Child who is alleged means a child who is alleged or who found to have committed an offense. A child who is alleged or found to have committed an offense. Who is alleged? जिसके ऊपर allegations है. देखो child in conflict means who is child who is alleged, जिसके ऊपर allegation है कि उसने offense किया है, और found to have committed an offense. Found to have committed an offense के इसका मतलब क्या है? After inquiry, the either Juvenile Justice Board or a Children's Court come to the conclusion that this child has committed an offense. See, two words are there. A child who is alleged or found to have committed an offense. Then second, and who has not completed 18 years of age. उसने 18 साल पूरे नहीं किए. कब? At the date of the commission of such offense. Means on the date of the commission of the offense, if the child is under the 18 years of age, though he is arrested after completion of 18 years of age, he will be tried, he will be inquired into as a child, not as an adult. Therefore, again, I revise the definition of subsection 13 of section 2. Define a definition child in conflict with law means a child who is alleged or found to have committed an offense and who has not completed 18 years of age on the date of commission of such offense. Here, these words are important. On the date of commission of such a, on the date of commission of such a offense. On the date of commission of such a offense. So, next. What is the definition of child in need of care and protection? See, this clause does not define what is by child in need of care. It means they are given the list. If such a circumstance arises, then that child is called a child in need of care and protection. I'll read a few only, not in detail. See, child in need of care and protection means a child who is found without any home. To which child we call it as a child in need of care and protection means a child who is found without any home or a settled place of abode and without any ostensible means of subsistence. Generally, we used to see such sentences in Hindi Muhi. Amar Akbar Anthony, Lavaris. So we watch these sentences in Hindi Muhi that the children scattered from the parents and they come on the street, and that time they don't have the home. They don't have the settled place of abode. They don't have any source of income. In that situation, those children have the child in need of care and protection. Then second, who is found working in contravention of the labor laws? For them in force. Most of the time we observe that in a city, in hotels, or any establishment, The children, because of their poverty, they have to work. They have to work. Who is found working in contravention of labor laws for the time being in force, or is found begging, or is living on the street. See, they are the children child in need of care and child in need of care and protection. उनको care करने की जरूरत है, उनका protection भी करने की जरूरत है. Second, third, who resides with a person and such person has injured, exploited, abused or neglected the child. Therefore, what I am telling you, if you watch the old movies, in a more movies you will find such stories are there. Who resides with a person and such a person has injured, exploited, abused or neglected the child, or has violated any other law for them in force, mean for the protection of the child, has threatened to kill, injure, exploit or abuse of the child, or there is reasonable likelihood of the threat being carried out, has killed, abused, neglected or exploited some other child or children, and there is a reasonable likelihood of the child in question being killed, abused, exploited or neglected by that person. So these are the examples. Who is mentally or physically challenged, that he is a child in need of care and protection. Who has a parent or guardian, such parent or guardian is found to be unfit. Sometimes the parents in such a situation, they are unfit to maintain their children. They are unfit to take the care of their children. In that situation, these children are the child in need of care and protection. So these are they have given the list which children are called as child in need of care and protection. Then child friendly. Whenever the Juvenile Justice Board or Children's Court will incur that case against the child in conflict with law, they will follow the child friendly atmosphere. That whenever they will inquire into the case of the child, that court will not as like an ordinary court. They will sit as they will sit not like as what we see in a court as the original court. Okay. Therefore, child friendly means any behavior, conduct, practice, process, attitude, environment, or treatment that is human considered and in the best interest of the child. It means whenever either the Juvenile Justice Board or Children's Court will try or will inquire into the case of the child in conflict with law, they will follow the child-friendly procedure. They will treat the child as like a friend. They will not even remind him that he is an accused. That will be a child-friendly atmosphere will be there. Okay, they will organize, they will arrange the inquiry in such a place where, as like a school, the walls will be painted with the pictures. They will sit in an informal way. Okay. Then there is a child welfare officer. Generally, the child welfare officer work for the committee, but sometimes he may work for the Juvenile Justice Board. Then CWPO. What is CWPO? Child Welfare Police Officer. Whenever the police apprehend, means arrest the child by ordinary police, they have to hand over to the Child Welfare Police Officer. Because Child Welfare Police Officer, he has taken the special training of a child psychology. And therefore, as soon as the police apprehend, means arrest the child, that child is handed over by the ordinary police to the Child Welfare Police Officer. And it is the duty of the child welfare officer to produce the child before the board within a period of 24 hours. Therefore, child welfare police officer means an officer designated as such under a section 1 of section 107. There are various types of phones in their children's home. Then courts in Juvenile Justice, I have already told the board, means the Juvenile Justice Board constituted under section 4, Children's Court. What is the board means? Juvenile Justice Board, and composition of the Juvenile Justice Board lies under section 4. Then Children's Court. See, I told you there are two types of the criminal code in a Juvenile Justice Act. One is a Juvenile Justice Board, and second is the Children's Code. Now here, subsections 20 of sections 2 define Children's Code means. Children's Code means a code established under the Commissions for the Protection of a Child Rights Act. Children's Code means a code established under the Commission. See, Children's Code means a code established under the Commissions for the Protection of a Child Rights Act. The Children's Code has been established under the Child Rights Act 2005. Okay, second, if there second, which Children's Code, which code act is Children's Code? One, the code which is established in the Child Rights Protection Act. Second, special code under the POCSO Act, under the Protection of Children from Sexual Offences Act. Then third is the court of session. If there is no Children's Code established by the Child Rights Commission Act, if there is no POCSO special code under the POCSO Act, then in that situation, the court of session of a district act as a Children's Code. Here, the court of session having jurisdiction to try offences under the act. Okay, that's court and then committee. Then another authority is there, Child District DCPU. Discipline District Protection DCPU, District Child Protection Unit. This is a very important authority or official. Here means a child protection unit for a district established by the state government, which is the focal point to ensure the implementation of this act and other child protection measures in the districts. Then fit person, that is guardian, is different thing. Then offense in Juvenile Justice Act, I have already taught you the chart in earlier concept. Even I have taught you this chart again. Then see the definition of petty offense, race offense, and heinous offense. Though I have taught you, but again we revise it. But the petty offense includes the offenses for which the maximum punishment. Petty offenses includes the offenses for which the maximum punishment under the IPC or BNSS or any other special law is imprisonment up to 3 years. जिस offense में 3 साल तक maximum imprisonment है, वो offense, वो act, वो that punishment is in their IPC, BNSS or any other law. That offense is for the petty offense. And which court, which authority has the power to decide the petty offense? Juvenile Justice Board. And Juvenile Justice Board can adopt the summary procedure. Got it. Then second, serious offenses includes the offenses for which the punishment under the IPC or BNS or any other law for a time in course is imprisonment between 3 to 7 years. देखो, जिस offense में 3 साल to 7 years, 7 साल तक है, 3 to 7 years. 3 साल के ऊपर 7 साल के अंदर 3 to 7 years है. So that offense is called as a serious offense, whether that imprisonment is above 3, under 7, under the IPC or BNS under the special law. Then these types of offense will be inquired into or tried by the Juvenile Justice Board. And a Juvenile Justice Board will follow the summons case procedure. Summons case procedure. Then heinous offense. Heinous offenses includes the offenses for which the minimum punishment under the IPC or BNS or any other law for a time in force is imprisonment for 7 years or more. See the language. जिस offense में 7 से 7 साल के ऊपर punishment है, इसका मतलब क्या है कि serious offense में 7 साल के अंदर है. जिस offense में 3 साल के ऊपर और 7 साल के अंदर punishment, that is a serious offense. Language is slightly, देखो 3 to 7. 3 to 7 means less than 7. यहाँ पे for 7 years, जिस offense में 7 साल तक या 7 साल के ऊपर punishment है. Language क्या है पेटी serious offense की? Is imprisonment between, अंदर है. 3 के ऊपर देखो up to 3 years petty offense. 3 के ऊपर and 7 के अंदर between है, अंदर है. बिटवीन वर्ड यहाँ पे, अबव 3, अंडर 7, क्योंकि यहाँ पे फॉर 7 years 7 साल या 7 साल के ऊपर, अप टू 3, above 3, under 7, serious offense, up to 3, petty offense, above 3, under 7, serious offense, up to 7, above 7, heinous offense. Heinous offense includes the offenses for which the minimum punishment, जहाँ minimum punishment 7 साल या 7 साल के ऊपर है, under the IPC or BNS or under any other special law, is imprisonment for 7 years or more. Is imprisonment for 7 years और देखो लैंग्वेज देखो, 3 साल तक पेटी ऑफेंस, 3 साल के ऊपर 7 साल के अंदर सीरियस ऑफेंस, और इनियस ऑफेंस 7 साल या 7 साल के ऊपर. नेक्स्ट जुवेनाइल मींस चाइल्ड बिलो द एज ऑफ 18 years अलग थॉट. ऑब्जर्वेशन हो ये अलग अलग ऑर्फन है. देयर आर 3 चिल्ड्रंस इन द जुवेनाइल जस्टिस केयर एंड प्रोटेक्शन एक्ट. What is see what I'm telling, there are 4 types of children in a juvenile justice protection act. One is a child in conflict with law, second is the child in need of care and protection, third is the child is free for adoption, and fourth is the child against whom the offense is committed. The third category, child is fit for adoption. See here there are 3 types of children who are given in adoption. One is a orphan child, second is a abandoned child by the parents, and third is a surrendered child by the parents. The first, orphan; second, abandoned; third, surrendered child. These 3 children are given in adoption under the Juvenile Justice Care and Protection Act. Okay. Here there is a probation officer. What is a probation officer? We'll look after it. There is another, there are CWPO, Child Welfare Police Officer, Child Welfare Officer. Then third officer is Special Juvenile Police Unit. Special Juvenile Police Units. SJPU. SJPU. Special O. Again, this what I thought child fit for adoption here. Abandoned child, surrendered child, orphan child. Then, whenever the court, either JJD or Children's Court or Juvenile Justice or Child Welfare Committee will pass the order, they will keep in mind certain principles while passing the order. That is, first, principles of presumption of innocence. Principle of presumption of innocence. Second, principle of dignity and worth. Third, principle of participation. Fourth, principles of best interest. Fifth, principles of family responsibility. Principle of safety. Positive measures. Principle of non-stigmatizing semantic. Principle of non-waiver of rights. Principle of equality and non-discrimination. Principle of right to privacy and confidentiality. Principle of institutionalization as a measure of last resort. Principle of repatriation and restoration. Principle of fresh start. Principle of diversion. Principles of natural justice. It means whenever either any authority, either the court, Juvenile Justice Board, or Children's Court, or the police, or a CWC, Child Welfare Committee, whenever they will take in additions under this act, they will keep in mind the principles stated in section 3. Now, next chapter 3, Juvenile Justice Board. See, chapter 3 deals with the compositions of the Juvenile Justice Board. Here, Juvenile Justice Board consists of the 3 persons. There shall be 1 judge. See, in order to deal with the cases of a child in conflict with law, the state government established the Juvenile Justice Board, and Juvenile Justice Board consists of a judicial magistrate of the first class with at least 3 years experience. See, right now we don't have the post of the Metropolitan Magistrate because of this because of this, see, this under the Bharatiya Nagrik Suraksha Sanhita, this Bharatiya Nagrik Suraksha Sanhita abolished the Metropolitan Magistrate post. Therefore, right now, only judicial magistrate first class who is having 3 years experience as a judge and 2 social workers, at least one of them shall be a woman. Okay, constitute this 3-person constitute bench. This 3-person constitute bench. One is a JMFC having 3 years experience and 2 members. One of them shall be a woman. Out of two members will be there, and one of them shall be a woman. And which person will be appointed as a member in the board? They should have at least experience of 7 years experience, 7 years experience in a health, education, and welfare activities, or they must be a practicing professional. They are appointed as a member. Okay, and who will not be appointed as a member? They will be on here. If those persons who have violated the human rights or child rights, they will not be appointed as a member in a juvenile justice board. Therefore, composition of a juvenile justice board consists of 3 persons. One is a JMFC having 3 years experience and 2 members. One of them shall be women. The members will be appointed. Those who have the 7 years experience in a health, other things, they will be appointed. Okay. Sometimes those who are the member of the Juvenile Justice Board, they will be removed from the post. They will be removed from the post of the member of a Juvenile Justice Board. Why? Because of the misconduct, because of the integrity. What happens in Porsche case? One of the members of the juvenile, what happens in Porsche case, I think 2 years ago, a children drove a Porsche car and killed 2 software engineers. And in spite of committing such a heinous offenses, they were drunken. They were produced before the Juvenile Justice Board. And one of the members asked the child in conflict with her write an essay, and then thereafter they release him on a bail. This act of the member was criticized by the media and by the people. Immediately, that member of the Juvenile Justice Board was removed from the board. Okay, therefore, here they are given has been guilty of misuse of power wasted under this act. He has been power. Okay, section 6 is there. Section 6 says placement of person who ceases to be child during the process of inquiry. Now, friends, what is the procedure? What procedure is followed? First, there is a registration of the FIR. After, what are the steps before preliminary assessment? See, first, after registration of the FIR, ordinary police apprehend means arrest the child in conflict with law. If the ordinary police arrest means apprehend the child in conflict with law, they immediately hand over the child in conflict with law to the child welfare police officer. Okay, and then child welfare police officer prepare the social background report. And the child is produced within 24 hours before the Juvenile Justice Board for further actions, along with the report by the child welfare police officer. And then child welfare police officer asks the probation officer to prepare the SIR. SIR means social investigation report. And the social investigation report is submitted by the probation officer within 2 weeks from the production of the child before the board. After producing, whenever the police arrest the child, whenever the police apprehend the child, and when the child is in their custody, within these 24 hours, if the child has committed a bailable offense, Even the police can release the child in conflict with law. Even the police can release him on a bail. If they don't release him on a bail, they have to produce the child before the board. Okay, and the board will pass the order for bail. Then projection of child before board within a period of 24 hours from the time of apprehending the arrest, excluding the time for journey. Then on projection of child before the board, CWSU produce the child welfare police officer produce the social background report of child, in which he mentioned the circumstances of apprehending the child, offense arrest to have been committed to the child, and thereafter the board take the decision regarding the bail shall be given to the child or not. Then child welfare police officer shall produce final report within 1 month from the projection of the child before the board. Therefore, in a Juvenile Justice Protection, in Juvenile Justice Care and Protection Act, 3 reports are prepared and produced before the Juvenile Justice Board. One is a social background report. Second is a social investigation report by the probation officer. And third is a final report prepared and submitted by the child welfare officer. These are the 3 reports. Then after completing this, if the child has committed heinous offense, and if he is above the age of 16 years of age, if the child is above the 16 years of age and there are 18 years of age, and if he has committed heinous offense, then the Juvenile Justice Board hold the preliminary assessment. I am telling the stages before the Juvenile Justice Board. First, registration of the FIR. After registration of the FIR, if the ordinary police arrest the child in conflict with law, they hand over the child to the child welfare police officer. And then child welfare police officer immediately forthwith prepare the social background report, and they produce the child before the either police release the accused on a bail if he has committed the bail offense. If they don't release him on a bail, then they produce the child in conflict with the before the Juvenile Justice Board. And that time, the child welfare police officer submit the social background report to the child welfare before the Juvenile Justice Board. Then before the Juvenile Justice Board, there are 3 reports. One is social background report. Second, report filed by the probation officer, that is social investigation report within 15 days, within 2 weeks from the date of the first protection of the child before the board. And third is a final report prepared by the child welfare police officer within 1 month from date of the protection of the child before the board. Then next stage, there is a preliminary assessment as per section 15. If the child is above the age of 16 and under the age of 18, and if he has committed the heinous offense, then the Juvenile Justice Board hold a preliminary assessment. Does the child has attained mental and physical capacity to commit the offense? Whether the child has the ability to understand the consequence of the offense. Then in what circumstances the child has committed the offense? See, whenever the Juvenile Justice Board hold a preliminary assessment in heinous offenses, they consider 3 things. First, whether a child has attained mental and physical capacity. Second, whether the child has the ability to understand the consequences of the act. Third, whether the child has understand the circumstances in which he has come to the offense. And if the Juvenile Justice Board come to the conclusion, yes, the child is above the 16 and under the age of 18 years, and he has attained sufficient maturity something, then Juvenile Justice Board refer this case to the court of children's court. And if the Juvenile Justice Board come to the conclusion, though the child is above the 16 under the age of 18 years, and he has committed the heinous offense, but the child has not attained sufficient maturity, sufficient mental and physical capacity, then the Juvenile Justice Board will not refer the case to the Children's Court. The Juvenile Justice Board will itself try that case and will follow the summons case procedure and will award only 3 years imprisonment. Okay. Okay, then if the Juvenile Justice Board thinks that in their preliminary assessment that child has attained a mental and physical capacity, then they will refer this case or transfer this case to the Children's Court. Now the matter is before the Children's Court. The Children's Court will again hold a preliminary assessment, because that is the assessment done by the JMFC, by the Juvenile Justice Board. They don't have that much experience. And Children's Court is the court of a session judge, and they have the wide experience. Again, the Children's Court will hold the preliminary assessment. And Children's Court will pass the 2 types of orders. If the Children's Court thinks that though the child is above the age of 16 under the age of 18 years, and second, he has come to the heinous offense, but the child has not attained the mental and physical capacity, then Children's Court will not try that child as an adult, but the Children's Court will try that child as a child, and they will follow the summons case procedure. And who will inquire his case? The Children's Court will inquire that case itself. Will follow the summons case procedure. It means the Children's Court will not remand that case to the Juvenile Justice Board. Instead of, Juvenile Justice Board has a 2 options. To try means inquire that case as a child, then they will follow the summons case procedure. They will set punishment. If they decided to inquire his case as an adult case, then they will follow the sessions trial procedure. And whenever the Children's Court means inquire any case as an adult case, then they will follow the session trial procedure, and they will not pass death sentence to the child. They will not award imprisonment for life without possibility of the release, but the Children's Court will award imprisonment for life but limited period. Most of the people will tell you that Children's Court cannot award the imprisonment for life. Yes, no, Children's Court can award imprisonment for life, cannot award the imprisonment for life till his natural death. The Children's Court can award, pass the sentence of imprisonment for life, but for a limited period, for 20 years, for 15 years. Okay, yes. See, 2 years ago, 2 or 3 years ago, an incident happens in Nagar city. When 17 years old boy in my locality, where I live in a N2 Circo area, that the 17 years old boy had committed murder of his father mercilessly. And the father was a professor in one reputed college. Then he had no repentance. Then on 10th December 2025, The Children's Court Session Court of our Sambhajinagar city awarded him imprisonment for life. Means the Children's Court can award imprisonment for life, but that imprisonment for life may be a definite period for 15 years, for 10 years, or 20 years. They cannot award imprisonment for life in still natural death, because you know that as per section 57 of the old IPC, that in a Gopal Gulse's case versus state of Maharashtra, the Supreme Court has said that imprisonment for life means till the natural death of the convict prisoner. Okay, here I told you about this is the situation. Therefore, section 5 says, I told you the stages of case before the either before the Juvenile Justice Board or before the Children's Court. Here again, section 5. Placement of person who ceased to be child during process of inquiry. The placement of person who ceased to be child during process of inquiry. Suppose we have studied one category. The child is above the 16 under the age of 18 years. Child is above the 16 under the age of 18 years. And on the date of the commission of the offence, child was under the age of 18 years. And during the course of inquiry means trial, if the child has attained the 18 years of age, that child will be tried as a child, not as an adult. This is section 5 says. Therefore, where an inquiry means trial has been initiated in respect of a child under this act, and during the course of such a trial, the child completes the age of 18 years, then notwithstanding anything contained in this act or any other law further in force, the inquiry may be continued. The inquiry means trial may be continued by the board, and orders may be passed in respect of such a person as if such a person had committed to be a child. Okay, I hope. We have studied the definite child in conflict with law. The child in conflict with law says on the date of the commission of the offence, if the child is under the age of 18 years, and during the course of trial means inquiry, if he completes the age of 18 years, it means he has become the adult. But even though the proceedings against him, trial or inquiry will be continued under the child, not as an adult. Section 5. Then section 6. Placement of persons who committed an offence when person below the age of 18 years. Placement of a person who committed an offence when person was below the age of 18 years. Now here there are 4 types of homes for a child in conflict with law. यहाँ पे जो भी कोई चाइल्ड कोई ऑफेंस करता है तो उसके लिए 4 प्रकार के होम यहाँ पे. पहले ऑब्जर्वेशन होम है. Whenever the police during the course of inquiry, if the child has not been released on bail, the child is kept in an observation home till the conclusion of the trial. During the pendency of the inquiry trial, child is kept in an observation home. And once the trial concludes, then he is kept in a special homes. Special home. And again, third home is there. Place of safety. If he has attained the 18 years of age, if he is above the 16 under the 18 years of age, then the child is kept in a place of safety. If the child has attained the age of 18 years, under the age of 12 years, 18, 20, 21 years of age, he is kept in a place of safety. And if the child has completed the age of 20 years of age, and yet he has not served the sentence, then that child is kept in the prison. Therefore, I am telling you four types of homes are there. First is a observation home during the course of pendency of inquiry. Then special home after the conclusion of the inquiry. Then third, place of safety. And fourth, prison. After completion of 20 years of age, the child is kept in a that child who become the adult is kept in the prison. तो 18 और 21 के अंदर कहाँ पे रखते हैं? प्लेस ऑफ सेफ्टी में. इसके पहले 16 से 18 कहाँ पे रखते हैं? स्पेशल होम में. और जब इंक्वायरी चले हैं, इंक्वायरी पेंडिंग है, तब कहाँ पे रखते हैं? ऑब्जर्वेशन होम. ऑब्जर्वेशन होम, स्पेशल होम्स, प्लेस ऑफ सेफ्टी एंड प्रिजन्स. Okay, therefore, what section 6 says? Placement of person who committed an offense when person was below the age of 18 years. Right? Any person who has completed 18 years of age and is apprehended for committing an offense when he was below the age of 18 years, then such a person shall subject the provisions of this section, be it a child, during the process of inquiry. उसने ऑफेंस किया, तब वो 18 के अंदर था, उसको अरेस्ट किया, वो कंप्लीशन होता है उसका 18 साल कंप्लीट होने के बाद अरेस्ट किया, तो he will be tried as a child. बराबर है यहाँ पे, he be treated as a child during the process of inquiry. Second है, the person referred in section 1, if not released on bail by the board, shall be placed in place of safety during the process of inquiry. जब उसे अरेस्ट करेंगे उस वक्त ऑब्जर्वेशन होम में रखेंगे, इंक्वायरी चलेंगे तो प्लेस ऑफ सेफ्टी में रख सकते हैं, बेल पे नहीं छोड़ा गया तो यहाँ पे किया. Procedure in relation to board. The board shall meet at such time, shall observe such rules in regard to transaction of the business. And again, what I told, they will follow the, whenever the board will hold an inquiry against the child in conflict with law, they will follow the child friendly procedure. कौन सी procedure follow करेंगे? Child friendly procedure. Okay, and यहाँ पे दिया है, venue is not intimidating to the child. और जैसा सिग्नेचर वहाँ पे नॉर्मल रूम रहेगा, हॉल रहेगा, जहाँ पे it does not look like a sport. The judges will not be with their costume or gowns, their robe. They will be in a simple dress. Police will not be there in a police uniform. Okay, that is a child-friendly atmosphere. Okay, then even a member of a child, member of the General Justice Board will. The child will be produced before a single member of the board is already not very. Here, a child in conflict law may be produced before an individual member of the board when the board is not in sitting. Okay. So here, friends, I completed one topic today. Will whenever I will get time, I will definitely. Let's see.
Thank you, sir. Sir, thank you. Dear friends, today respected sir has completed his first part of the lecture on the Juvenile Justice Act. Sir has already assured us that he will deliver the remaining second part of the lecture in the next week. I express our sincere gratitude to Professor KOLTE sir for delivering such an insightful and enriching lecture on the Juvenile Justice Act 1986. Sir, your guidance has truly helped all the aspirants to understand this important subject in a clear and practical manner. Once again, thanks to all for warm response. Good night and see you all in tomorrow's lecture.
Thank you, sir.
Good night, sir. Good night.